Sparks in the courtroom. Donald Trump finally testified in open court, and it did not go well. In just one incident in the New York Attorney General's $250 million civil fraud case, Trump repeatedly pulled out a piece of paper out of a suit jacket, sparking conflict with Judge Arthur Engoron. And when Trump asked Engoron if he, quote, would like to see it, the judge reacted like any sensible person who has just been asked if he wanted to see what a man is keeping in his pocket.
I don't need to see that.
But the art of the deal says never take no for an answer, so nevertheless, Trump persisted. He said, quote, I would love to read this, Your Honor, if I could. Am I allowed to do that? The judge was irritated, telling Trump again, no, not at this point. But Trump insisted that the paper would completely clear his name. What was this mysterious piece of paper? Well, Trump believes that he can win the civil trial with one weird trick, a disclaimer clause on his financial statements. And he said, quote, I think that the statements of financial conditions were very good, were actually somewhat conservative, and they were totally protected, and so am I by the disclaimer clause. But the thing is, before trial, Judge Engoron had already ruled that the disclaimer doesn't insulate Trump from his fraud claims. So the judge told Trump to, quote, read my opinion again, or for the first time, perhaps. And Trump professed to be shocked by the judge's refusal to read the piece of paper. Quote, he called me a fraud and he didn't know anything about me. But the thing is, judges get to decide matters of law before the trial even starts, and the judge had already decided that the disclaimer wasn't a valid legal defense. But yeah, Trump really was losing control and really was yelling and pointing at the judge while on the witness stand. He continued, quote, the fraud is on the court, not on me. The fraud is on her. Here Trump was referring to Tish James. Quote, I think she is a political hack. She used this case to try to become governor. This is a disgrace. All you have to do is read the legal papers and the scholars. This is a political witch hunt, and I think you should all be ashamed of yourself. Now, it should probably not surprise you to learn that generally witnesses don't get to introduce things into evidence by pulling objects out of their sweaty underclothes. And the financial statements at issue here, which all contain the disclaimer, had already been admitted into evidence. But Trump was determined to have some kind of Perry Mason moment, and this led to some intense moments between him and the judge. And this was just one of the insane things that happened when Donald Trump took the stand in the New York Attorney General's civil fraud trial. And the trial isn't even over yet. But a lot has happened, so let's talk about what happened when Trump took the stand. Now, through all this, Trump has requested that his trials be televised. And I hate to say it, but I really agree with the former president on this point. Some people claim it would be good for Trump, some people claim it would be good for prosecutors, but either way, this is of national importance, and it really seems like the public has a right to know. Sadly, here, this trial is not televised, so unfortunately we have to rely on secondhand accounts. But there were a lot of people taking seemingly very good notes during this whole thing. Now, as you may recall, this trial stems from a civil lawsuit filed by the New York Attorney General, Letitia James. The lawsuit accuses Trump, John Jr., Eric, the Trump Organization, and several company executives of inflating the value of the Trump Organization's assets and Trump's personal wealth to obtain better terms on loans and insurance. The New York Attorney General wants to recoup $250 million and limit the Trump's ability to do business in New York. And before the trial, Judge Arthur Engoron already ruled that Trump committed financial fraud by overstating the value of his assets, and he canceled the New York business certificates of several of Trump businesses. That order is stayed pending appeal. Now, the current trial will resolve the other fraud claims and determine what penalties the Trumps must pay. During the trial, Trump has continually accused Judge Engoron of pursuing him for political reasons, and after he shared a social media post attacking the judge's principal law clerk, Judge Engoron issued a limited gag order. Now, Trump violated that order twice, and Judge Engoron has fined him $5,000 and then $10,000. And because of this conduct, Trump was forced to take the stand for the first time to defend the references that he was making in the media, where he claimed that the witness that he was referring to was Michael Cohen, not the judge's clerk, but Judge Engoron all but called Trump a liar. He said, quote, as a trier of fact, I find this testimony rings hollow and untrue. The Oxford English Dictionary defines alongside as close to the side of, next to. So yeah, probably not how you want your first testimony in that court to go. But the judge's gag order initially only applied to Trump, but then Trump's lawyers, Christopher Kise and Alina Habba, started criticizing the clerk during trial. They argued that she was passing the judge notes and that this was evidence of anti-Trump bias. Clerks communicate with their judges. That's a perfectly acceptable practice, as I'm sure Kise and Habba surely know. Judge Engoron then extended the gag order to limit Kise and Habba, and that too is now on appeal. But things went equally poorly when Trump took the stand in the case in chief. When Trump took the stand, he clashed with the judge immediately, giving long-winded answers and serving up political monologues. Kise told the judge that Trump's decades as a real estate developer gave his opinion extra weight. Quote, if my choices were Donald Trump or Attorney General James, respectfully, I would go with Donald Trump. Keyes urged the judge to give Trump, who he described as the once and future president, leeway to answer questions the way that he wanted to. Quote, with this witness, I would suggest it's far more efficient to listen to what he has to say and take it in. But that comment struck a nerve with Judge Engoron. He said, quote, no, I'm not here to hear what he has to say. I'm here to hear him answer questions. Sit down. Judge Engoron said he was considering drawing negative conclusions from Trump's testimony. Quote, we got another speech. I beseech you to control him if you can. If you can't, I will. I will excuse him and draw every negative inference that I can. Now remember, this is a bench trial, so Engoron is acting as the trier of fact, who will decide what really happened. Here, there's no jury, famously because it seems that Trump's lawyers did not request a jury or check the box that would have created a jury in this situation. It's actually incredibly normal for a judge to be the trier of fact instead of a jury. It happens all the time, especially in business-related matters. But here, I think it was clear that Trump's team wanted a jury and just forgot to check the box. But later on in the questioning, Trump was especially triggered by questions about Mar-a-Lago, the Florida golf club where he resides for most of the year. Engoron's pretrial ruling finding Trump liable for fraud noted that the local assessor valued Mar-a-Lago at $18 million, while in documents Trump valued it at hundreds of millions more. Now, obviously the assessor's opinion was only one and was not dispositive, but Trump certainly didn't back down and went the other direction, insisting that he believes the club is worth as much as $1.5 billion. Now, the Attorney General has argued that Mar-a-Lago would never be valued that high because the property is deed restricted and cannot be used as a residence or be developed. And Trump said that he agreed to the deed restriction for tax purposes. He admitted that the lower assessed value limits the property's tax burden. Quote, there are a lot of advantages to the club status. The smartest thing to do would be to have a club and have one member. Now, as you can probably tell, Trump is going to need a good lawyer on appeal to help him with his terrible testimony. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find you the right attorney who can. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So the link is down below. Now, this isn't the worst argument in the world. Arguing that a clause that the court has already ruled several times doesn't say what you say it says is the worst argument, but it's still not very good. Because in 1985, Trump purchased Mar-a-Lago from the Post Foundation and used the estate as a private residence until 1995. Trump faced hostility from Palm Beach residents who blocked his attempt to subdivide the property into multiple housing lots. So in April of 1995, the estate became a private club. Trump signed an agreement with the city banning club members from spending more than 21 days a year at the club's guest suites. Trump also granted conservation easements to the National Trust for Historic Preservation. And in 2002, hoping to reduce his tax bill, Trump granted a new development easement to the Historic Preservation Trust. It, quote, limits changes to the property including without limitation, division, or subdivision of Mar-a-Lago for any purpose including use as single-family homes, the interior renovation of the mansion, which may be necessary and desirable for sale of the property as a single-family residential suite, the construction of new buildings, and the obstruction of open vistas. The deed says, quote, the club and Trump intend to forever extinguish their right to develop or use the property for any purpose other than club use. And according to Trump, the deed language is not legally binding. He said, intend does not mean we will do it. If someone wanted to change it later, I believe they would have the right to do it. But Trump stopped short of saying he believed the property could be developed into a private residence. Quote, if somebody wanted it, the smartest thing to do, have a club and have one member, and that would be the member who lives in the club. But it's much more valuable and will show that in 2 weeks or 5 weeks or 9 weeks or whenever this thing goes, that its biggest value is in using it as a club. And although conservation easements in Florida are said to be perpetual, they can be amended or released by agreement with the easement holder. The National Historic Preservation Trust has agreed to amend conservation easements to allow development in the past. However, releasing an easement is controversial and is not guaranteed. The property sits on 17 acres between the Atlantic Ocean and Lake Worth, so Trump is right that it's potentially worth a lot of money. But Judge Engoron relied on the tax assessor's value, which put the market value of Mar-a-Lago at between 18 and 27.6 million. Now that's probably on the low end, especially since tax assessor valuations tend to be low. But at the end of the day, the tax assessor's value is still based on what Trump was telling the local tax assessor the property was worth, and that's a number based on his desire for low taxes and all the encumbrances on the land. And it sounds like Trump knows he might not have a legal right to build private residences on the property, but he leaves open the possibility of negotiating different restrictions with the National Trust. He can also argue that even with the deed's broad language, there's still things that he can do to develop the property that would make the valuation higher. But Trump could also face opposition from the US Treasury. If the easement was subject to an income tax deduction, then Treasury regulations suggest that easements must be perpetual and would need to be extinguished by a court. And prosecutors confronted Trump with his own comments about the 40 Wall Street property, which he valued at more than $500 million. In 2009, Capital One expressed concerns about Trump's cash flow. The bank had lent him $160 million, and Trump was claiming that 40 Wall Street was worth $500 million, even though the building only produced $9 million in revenue that year. According to the Attorney General, Capital One met with Trump, and commercial real estate firm Cushman & Wakefield came in to assess the asset, determining it was worth $200 million as of August 1st, 2010. Trump, however, insisted the building was worth much more, at least $600 million, because it was allegedly making around $50 to $60 million per year. Trump apparently made these comments to a Forbes reporter on tape, but he told the court that he did not recall making the statements.
Where did you get that from?
Well, we're here to listen to what you have to say.
$64 million net after debt service this year, at least.
In a 2022 article, Forbes reported that Trump admitted in 2015 to his own involvement in bolstering his assets because a high net worth is, quote, good for financing. Trump first denied telling Forbes that he needed a good net worth, but then admitted that having a high net worth is helpful for some kinds of financing. 40 Wall Street apparently has never gotten close to raking in $50 million per year. Annual net operating income peaked at $20.7 million in 2018. And the Attorney General showed through Trump's testimony that despite much lower and sometimes even negative net revenue from leasing that same building, Trump used that $500 million valuation to get better loan terms. And Trump testified that the value of his property at 40 Wall Street is hundreds of millions of dollars more than what she says. She doesn't even know what 40 Wall Street is. And that led to a very testy lunch break. During the break, the parties continued to squabble, and Trump made a Truth Social post that only quoted part of the judge's quote, saying, "No, I'm not here to hear what President Trump has to say," and then left out the other part and all of the context of that particular quote. Then Attorney General James took to Twitter to fire back at Trump's testimony that she doesn't know what 40 Wall Street is, saying, quote, "Don't tell, I can see it from my office window." And then Trump's attorney, Alina Habba, spent her lunch break explaining herself to an NBC News correspondent, quote, "When I followed up on if she is urging Trump to answer more concisely, knowing Engoron will be the one delivering penalties stemming from the suit, Habba said that she would not tell Trump that because she would not agree to represent someone and then try to limit their free speech." And then Habba later stood outside the courtroom and went into a full-on rant about the judge. She said Judge Engoron turned red with rage when Trump testified and accused him of wanting to silence Trump.
Then why exactly am I being paid as an attorney, and why exactly are taxpayer dollars being used in this courtroom? You have a right to hire a lawyer who can stand up and say something when they see something wrong. But I was told to sit down today. I was yelled at, and I've had a judge who is unhinged slamming a table. Let me be very clear. I don't tolerate that in my life. I'm not going to tolerate it here. And you know what? You shouldn't either.
Wow. Yeah. So basically, you can tell that they know they are getting absolutely screwed in the courtroom and are trying to try their case in the court of public opinion. This is a very unusual move, sure to piss off the judge. And it just doesn't recognize that judges have discretion to run their courtrooms how they want. And as a lawyer, usually you just have to live with it. They might be trying to save some things for appeal, but a lot of the day-to-day stuff that happens inside of a courtroom is unappealable, and they're just going to have to live with it. Clearly, they are trying to do some stuff that is good for them in an extrajudicial context, but yeah, things are going from bad to worse inside of the courtroom. And then after lunch, the prosecutor questioned Trump about several loan agreements with Deutsche Bank. When Trump developed the old post office property in Washington, D.C., he had to agree to certain representations to get the loan. He affirmed to the bank that he had a minimum required cash balance, a minimum total net worth, and provided fair and accurate financial statements for the current and prior years. The Attorney General is trying to prove that Trump and his co-defendants deceived the bank to get favorable terms and a lower interest rate. And notably, Trump sold the old post office lease last year for $375 million. And Trump was expected to receive $126 million, with each of the adult kids expected to receive roughly $4 million from the sale. Trump affirmed that the total proceeds were $139 million. And I'm sure the Attorney General will argue that the state should be allowed to claw back those profits. Trump argued that he complied with the lending requirements, even though it doesn't look as if he was really worth $2.5 billion, as he alleged. Quote, "The numbers are far greater than the $2.5 billion, therefore you have no case." Now, one of the covenants that Trump affirmed to get the bank to lend is that his statement of financial condition are true and accurate in all material respects. However, when Assistant Attorney General Wallace asked Trump about the valuations of specific properties, Trump claimed that the documents included a disclaimer that absolved him and the company from liability for inaccuracies. Quote, the disclaimer clause says, if there's a mistake, if there's something, don't rely on it. They always hold up in court, except maybe this court. Trump has been calling this a worthless clause.
But we have a clause in the contract. It's like a buyer beware clause.
Trump is referring to the disclaimers that his accountants included on the statements of financial condition. The disclaimer says that these statements were not audited and the company can't say whether the financial statements comply with generally accepted accounting principles. But Judge Engron, as we've talked about, has already rejected this argument in his pretrial order. Quote, defendants' reliance on these, quote, worthless disclaimers is worthless. The worthless clause does not say what defendants say it says, does not rise to the level of an enforceable disclaimer, and cannot be used to insulate fraud as to facts particularly within defendants' knowledge, even vis-a-vis sophisticated recipients. And given this earlier ruling, Judge Engron wasn't willing to let Trump testify repeatedly that the disclaimers absolved him from liability. And even if this order did not already exist, witnesses are there to testify about facts and generally cannot testify to their opinions about legal issues. Now, the Attorney General was arguing that Trump was desperate to inflate his personal wealth and that he told his family and company executives to manipulate the numbers. When Trump was asked about the valuations of specific properties, he insisted that some of the numbers were inflated because property values increase over time. In fact, discussing property valuations for 2014, Trump said, quote, if you carry that forward to 2021, all of those valuations were low. So in Trump's mind, if a property was going to be worth more almost a decade later, he was justified in simply adding that increased value back in 2014. Not surprisingly, Judge Engron previously rejected this argument. But then Trump testified that the valuations weren't accurate anyway because they didn't include his brand value, i.e. the value that Trump attributes to the Trump brand name. AG Wallace pounced on this response. Quote, are you testifying that these financial statements are not accurate? And then Trump tried to walk back the response by saying that they were accurate except for the brand value, plus the error he made in the square footage of his penthouse, plus an error in the overvaluation of the Seven Springs property. So yeah, a lot of errors. Now, Trump was also testifying that the banks didn't care about his financial statements and that the banks loved Trump because he helped them make money. However, when Wallace showed Trump a loan agreement he had signed with Deutsche Bank in 2012, Trump agreed that his financial statements were intended to induce banks to lend money. And that's a key element of the Attorney General's fraud case. Despite Trump's denial to the contrary, the statements were designed to get favorable loan and insurance terms. Trump then launched into a monologue about what his bankers will say and stressing that the financial statements were not really documents that the banks paid much attention to. They looked at the deal, they looked at the asset. If it is real estate, they looked at the location. Though a retired Deutsche Bank official had already testified that Trump's financial statements were the linchpin in his loan approvals. She also said that although the bank didn't do full appraisals, it sometimes gave haircuts to Trump's valuations. She said the bankers called them, quote, sanity checks on Trump's most outrageous numbers. And Trump testified that he relied on two longtime Trump Organization executives and an outside accounting firm to prepare his financial statements. He said ex-CFO Alan Weisselberg would give him a draft before each year's statement was finalized and that he'd, quote, look it over and maybe have a suggestion, but it wasn't very important. You've made it important, but it wasn't very important to me. And the Attorney General's office asked Trump about the trust he established to manage his assets before he entered the White House. They established that Trump restored himself as the sole trustee shortly before Biden's inauguration, but then gave up control again in July of 2021, just days after Alan Weisselberg and the Trump Organization were indicted for tax fraud. At first, Trump claimed that he made Don Jr. his trustee because he trusted his business acumen and was returning to politics. But on cross-examination, Trump agreed that he did so because of increasing legal pressure. Quote, you and about every other Democrat district attorney, AG, and U.S. attorneys were coming at me from 15 different sides, all Democrats, Trump haters. Weisselberg pleaded guilty to tax fraud, and Wallace wanted to know if this changed Trump's opinion of Weisselberg's work for the company. Trump said yes, that Weisselberg was persecuted by the state because of his relationship with Trump, and Trump admitted knowing that the company was paying for Weisselberg's apartment, which was an issue in the tax fraud case. But Trump denied knowing that Weisselberg was reporting transactions inaccurately in the books and records of the company. Trump says that he learned that only in connection with the tax fraud trial. Now, what's really interesting is that Trump's testimony has been covered extensively by more than 200 news outlets. 32% of the reporting is coming from the left, and 26% is coming from the right. And if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have outlets using terminology like temper tantrum and out of control with reference to Trump's disposition, while on the right, you'll find outlets using words like tangles or clashes. Now, these word changes are subtle, but they play a big role in how readers perceive the story. The first set of words might imply that Trump alone is acting out, while the second set of words might imply that Trump is defending himself against statements from the judge. Now, this is all possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. And I especially like the new Ground News comparison feature, which highlights specific differences between the left and right reporting. For stories on Trump's testimony, you can see that left-leaning outlets tend to focus on the trial itself, and that Judge Engoron has stated he'll draw negative inferences from Trump's testimony, while the right focuses on statements by Eric Trump attacking New York and saying the city is going to hell. And Ground News also has a blind spot feed, which highlights stories that are disproportionately covered by one side of the political spectrum. This is so important so we don't live in an echo chamber or get misled by subtle and sometimes not so subtle language in the news. So try out Ground News by clicking on the link that's on screen or down below. Just for Black Friday, starting now and continuing through November 30th, you can get their biggest sale of the year. Right now, you can get a 40% discount on Ground News' Vantage subscription. Their subscription includes unlimited access to all Ground News features, and with the sale, the subscription is only $5 a month. It's the biggest deal of the year. So go to ground.news/LegalEagle or click on the link below and you'll get a 40% discount to get unlimited access to their app, website, and newsletter for just $5 a month. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.